Imagine sitting in your hometown, just, idly scrolling on your phone. You see a political cartoon, maybe a news article, and you hit retweet.
Yeah, just a completely normal, everyday thing.
Right, and then you just go about your day. But a few days later, the police kick your door down, they confiscate all your devices, and eventually a court hands you a 20-month prison sentence.
Just for a retweet.
Exactly. Today, we're looking at how that incredibly simple act of sharing a post turned into this high-stakes masterclass in the philosophy of truth.
Yeah, we are dissecting a case that really forces us to examine the very fabric of how a society defines what is a fact, what is an opinion, and ultimately what actually constitutes a crime. It is this brilliant collision of network physics, legal theory, and epistemology.
Welcome back to another deep dive. We are thrilled you're here with us. Yes, you, the ever-curious learner trying to make sense of a highly complicated world. We are pulling from an incredible stack of source materials today. We've got legal documents, court appeals, and this really profound philosophical blood letter written from a prison cell in China.
It's a fascinating stack of documents.
It really is. Now, before we jump in, I want to explicitly state something for you, our listener. Because these sources touch on highly politically charged content regarding the Chinese government and international relations, we are not taking any sides today. We aren't endorsing the viewpoints of the original tweets or the government. Our mission is strictly to impartially unpack the fascinating legal, philosophical, and systemic arguments presented in the source material.
Right. We are acting purely as intellectual forensic investigators here. The goal is to look at the structure of the arguments and the underlying logic of the legal system, not to pick a political team.
Perfect. So let's set the stage. The year is 2022. The place is Kunming, China. And our focal point today is Dr. Chen Jingwen.
Yeah, and his background is super important here. He is a highly educated scholar who holds a PhD.
Right. He spent years researching complex systems, things like physics, artificial intelligence, neural networks, heavy academic stuff.
Exactly. And he had moved back to his rural hometown to care for his aging parents and just sort of live as an independent scholar.
Then, out of nowhere, Kunming police burst into his home and arrest him. And his crime was using a VPN to casually retweet posts on X, which was, Twitter at the time.
And the charge wasn't espionage or treason or anything like that. Dr. Chen was charged with, and eventually convicted of, picking quarrels and provoking trouble.
Picking quarrels and provoking trouble.
Yeah. In the Chinese legal context, scholars and lawyers frequently refer to this as a pocket crime.
A pocket crime. I mean, the imagery there is incredibly vivid.
It really is, right?
It implies a crime that is so loosely and vaguely defined, the authorities can just stuff almost any behavior into its pockets if they feel the need to make an arrest.
Exactly. And what's fascinating here is the prosecution's specific claim. They argue that Dr. Chen spread false information that caused serious confusion of public order.
Serious confusion of public order.
Right. But what elevates this from just a standard legal brief into a goldmine of philosophical inquiry is how Dr. Chen chose to fight back.
Because he didn't just claim he was factually innocent of a specific act, did he?
No, not at all. He actually used his background in complex systems and philosophy to completely deconstruct the state's legal definition of a rumor.
Okay, let's unpack this. Let's start with the physics of a retweet, because he completely dismantled the idea that he caused a serious confusion of public order.
This part is brilliant.
I mean, Dr. Chen had fewer than 100 followers on his account. The sources note that most of those were likely just inactive or zombie accounts.
Right, he was barely broadcasting to anyone.
Exactly. His total lifetime retweets across all his social media platforms were under 100.
So, to understand his defense here, we need to look at the concept of informational entropy within complex networks.
Okay, entropy. Break that down for us.
Sure. In network physics, entropy basically measures the amount of unpredictability or chaos within a system. For a piece of information to cause a confusion of public order, it has to propagate.
It has to travel.
Exactly. It has to move from node to node across a network until it reaches a critical threshold and triggers a cascade effect.
Sort of like a virus spreading through a densely populated city.
Yes, perfect analogy. Which requires a highly connected, active network to amplify the signal.
And Dr. Chen argued that his specific node in the network was simply too small and isolated to cause any informational entropy?
Right. The causality is physically broken. There was zero real-world chaos.
Because the state couldn't point to any offline protests, right?
None. No offline protests, no crashed servers, no measurable public panic resulting from his account.
So from a physics standpoint, he wasn't even close to creating a ripple, let alone some kind of societal cascade.
Exactly.
It's like getting arrested for inciting a riot because you whispered a secret in an empty room.
That analogy captures the physical reality perfectly. There's no riot, and there's nobody even listening. The prosecution could not demonstrate any material impact.
Hold on, though. I want to play devil's advocate for a
Not
second.
about it.
Even if the room is totally empty, what if the information you whisper is inherently dangerous or legally classified as false?
Okay, I see where you're going.
Yeah, because the state didn't just say he caused chaos. They explicitly said he spread rumors. How did the court actually prove that the specific content he retweeted consisted of deliberate lies?
And that is where Dr. Chen lays a brilliant trap for the prosecution. Because the court didn't prove it on a case-by-case basis.
Wait, they didn't?
No. They essentially gathered up all of his retweets, bundled them into a single pile, and just slapped the label of rumor on the entire collection.
Oh, wow. That's incredibly broad.
Very broad. So to expose why this is logically absurd, Dr. Chen categorized his own retweets into 4 distinct types of human expression.
Right.
He argued the police and the court had committed a massive category mistake.
A category mistake. We should definitely break that down because it's a foundational concept from the philosopher Gilbert Ryle.
Yes, Ryle introduced this concept in the mid-20th century to describe what happens when someone presents things of one kind as if they belong to another.
Like mixing up the fundamental nature of 2 different things.
Exactly. His classic example is a visitor taking a tour of Oxford.
Okay, the Oxford tour.
Right. So the visitor is shown the library, the classrooms, the scientific laboratories, and the dormitories.
They see all the buildings.
Right. And at the end of the tour, the visitor looks around and asks, but where is the university?
Ah, I see. The visitor is looking for a specific building with a sign that says university.
Exactly. They don't realize that the university is the collective institution comprising all those other elements.
So they are assigning the wrong conceptual category to the object they are looking for. They're looking for a physical structure when they should be looking at an organizational concept.
Nailed it. So Dr. Chen takes Ryle's theory and applies it to human expression. He divides his retweets into 4 categories.
Okay.
1, art. 2, subjective emotion. 3, rational viewpoints or academic analysis. And 4, objective facts.
And his core argument is that the first 3 categories, by their very nature, cannot legally or logically be defined as rumors.
Exactly.
Let's apply Ryle's theory to those first 2 categories, art and emotion, because the examples from the sources are just wild.
They really highlight the absurdity of the charges.
Yeah. For example, under the art category, Dr. Chen retweeted a comic by an artist named Guo Jingsheng. It was called Hong Kong Umbrella Girl.
Which was a symbolic visual reference to the 2019 protests.
Right. And under emotion, he retweeted posts expressing personal sadness over U.S. chip bans affecting China and images commemorating June 4th.
So consider the legal definition of a rumor.
Okay.
In criminal law, for something to be a rumor or false information, it has to be a statement of objective fact that can be empirically proven false.
Like saying the sky is green when we can prove it's blue.
Right. Or the color of a car, the amount of money in a bank account, the time of day an event occurred, things you can verify.
Which means calling a cartoon a rumor is a textbook category mistake.
Exactly.
A drawing of a girl holding an umbrella is an expressive symbol. It relies on metaphor. You can't ask if a metaphor is factually accurate any more than you can ask if the color blue weighs 10 pounds. It's just a nonsense question.
A completely nonsense question. And the same logic applies to subjective emotions.
Right, because feelings aren't facts.
Exactly. A feeling of sadness or frustration doesn't have a true or false value.
Right.
If I say, I am sad about this economic policy, you cannot take me to court and mathematically prove my sadness is false information.
No, you can't audit a feeling.
By applying the criminal label of rumor to a cartoon or a sigh of frustration, the court treats an aesthetic expression or a value judgment as if it were a verifiable data point.
So, by legally classifying a feeling as a rumor, the court isn't just stretching the definition of a law. They are crossing a massive boundary and effectively criminalizing human psychology.
Right. The sources actually draw a direct comparison to prosecuting thought crimes.
Wow. Thought crime.
Yeah. When a legal system decides that an emotional reaction or an artistic preference can be deemed false information simply because it doesn't align with the preferred narrative, that system is no longer regulating physical actions.
It's going after the mind.
It is attempting to regulate and prosecute internal mental states. It destroys the foundational boundary between fact and feeling.
Man, that is chilling. And if criminalizing a cartoon is legally absurd, applying that same logic to political science and academic commentary actually breaks the mechanism of human progress.
It completely shuts it down.
Here's where it gets really interesting. This brings us to his third category: opinions, academic analysis, and rational viewpoints. Dr. Chen retweeted several political commentaries that expose the danger to knowledge itself.
The examples in this category perfectly illustrate the difference between an ideological opinion and a factual lie.
I want to walk you, the listener, through a few of these specific examples because they highlight exactly what was on trial here.
Yeah, let's go through them.
First, Dr. Chen retweeted a sarcastic prediction. The tweet joked that Chinese state media would soon start praising paid internet trolls known as the Wuma, or 50-cent army, after the media had already praised unpaid volunteer defenders of the state called the Ziganwu. It was purely satirical.
And a prediction about the future, especially a satirical one, inherently lacks a truth value in the present.
Because it hasn't happened yet.
Exactly. You cannot empirically falsify a joke about something that hasn't happened yet.
Okay, here's another one. He retweeted a historical anecdote from 1986. The story goes that Deng Xiaoping gave an interview saying he wanted to retire, but the people wouldn't let him.
Right.
So an editor at the Shenzhen Youth Daily named Cao Chengqing took him at his word and wrote an article agreeing that Deng should retire.
And I'm guessing that didn't end well for the editor.
No, the editor was promptly fired. The punchline of the retweet was, "You can't even agree with the leader."
And that is a political observation meant to highlight a systemic irony. It is a critique of power dynamics. It's not a rumor.
The third major example involved Tsinghua University professor Xu Zhangrun. His arrest had been reported by Radio Free Asia. Later, a journalist named Gao Yu tweeted a photo of Professor Zhu after his release.
The one with the dismissal paper, right?
Yes, in the photo, Xu is holding his official university dismissal paper, but he's laughing. The tweet called the university accomplices. Dr. Chen simply retweeted that photo in commentary.
If we connect this to the bigger picture, Dr. Chen argues, and the sources strongly support this, that these retweets belong entirely in the realm of ideological debate.
Not facts.
Right. To understand why criminalizing this is so dangerous, we have to look at the philosophy of science, specifically Karl Popper's theory of falsifiability.
Oh, I am so glad you brought up Popper. Let's really break down falsifiability because it is crucial here.
It really is the cornerstone of academic thought.
Popper argued that for any theory to be considered scientific or academic, it must be inherently capable of being proven wrong.
Yes, and that is the engine of all academic and societal progress.
How so?
Well, you propose a theory like, this economic policy will increase employment. That theory is tested against reality. Others debate it, attack it, and try to falsify it.
They try to find the holes in it.
Exactly. If it survives the testing, we accept it for now. If it fails, we discard it and learn something new.
So theories and opinions are designed to be debated in the public square.
Always. They are never meant to be adjudicated as absolute true or false facts in a criminal court upon the moment of publishing.
But let me push back on that application for a second.
Sure.
If I publish an opinion saying, the mayor's new policy is going to bankrupt the city, and the state's accountants look at the projections and say, I'm completely wrong.
Okay.
Why shouldn't the state be able to charge me with spreading a false rumor that damages the city's reputation? I mean, where does the law draw the line between a controversial opinion and a deliberate lie?
That scenario highlights the exact trap the authorities fell into. The law must draw a strict line at verifiable physical reality.
Verifiable physical reality. Give me an example of a deliberate lie.
A deliberate, prosecutable lie looks like this. The mayor stole $5 million from the Treasury yesterday.
Oh.
That is a claim about a physical event that could be audited and proven definitively false.
Right.
Saying, the mayor's policy will bankrupt the city is a value judgment about future outcomes.
Ah, I see. One is a statement of an event, the other is an interpretation of a trajectory.
Exactly. When the state fails to distinguish between the two, they take ideological disagreements, like satire, academic critique, historical interpretation, and shove them into the criminal category of rumor-mongering.
So they mix up the categories again.
Yes. And by doing so, the justice system stops being a neutral arbiter of the law and transforms into an ideological referee.
Which means Intellectual progress just hits a brick wall.
Pretty much, yeah.
If you can't propose a controversial idea or critique a policy without risking a 20-month prison sentence for spreading rumors, people will just stop thinking out loud.
That's the chilling effect.
You replace the academic pursuit of truth through debate with the administrative declaration of truth by authority.
It weaponizes the concept of a rumor to silence any thought that deviates from the approved consensus.
Wow. Okay, that covers art, emotion, and opinion. But what about actual objective facts? That leaves the fourth and final category.
Yes, the final piece of the puzzle.
This is the only area where a rumor could theoretically exist, right? Because facts can actually be proven true or false.
Exactly. And this is where the case shifts from philosophical definitions into the legal battle over the burden of proof.
Dr. Chen did retweet a couple of things that made concrete factual claims.
He did.
For example, he retweeted a post showing the alleged pension slip of a former Chinese government minister named Zheng Tubin.
Right, the pension slip.
The slip claimed this official was making over 49,000 RMB a month in retirement, and the post used this to criticize the lavish privileges of high-ranking officials.
A very specific financial claim.
Yes. He also retweeted a video of a speech given by U.S. Secretary of State Mike Pompeo at the Nixon Library in 2020.
And that speech had a very specific diplomatic framing.
It did. In that speech, Pompeo explicitly differentiated the Chinese people from the Chinese Communist Party, stating they were not the same entity.
Regarding these objective claims, Dr. Chen's defense is brilliantly grounded in practical reality.
How so?
Well, he points out his own status. He is an independent scholar living in a rural village. He does not possess the investigative resources, the subpoena power, or the intelligence agencies required to forensically fact-check a former minister's official pension slip.
No, of course not.
Nor does he have the capacity to verify the complex diplomatic nuances of a foreign secretary's public address.
Think about your own habits for a second. Do you, the listener, pause to fact-check the primary source documents, run reverse image searches, and audit the financial claims of every single news clip or meme you share online?
Oh, you know that.
Of course not. It's practically impossible for an individual.
And legally, you shouldn't have to. The burden of proof in criminal law rests entirely on the shoulders of the prosecution.
The state has to prove it.
Yes. The state must prove two separate elements beyond a reasonable doubt. First, that the information shared is definitively objectively false.
Okay, that's step one.
Second, that the defendant possessed the subjective intent to spread a rumor.
Subjective intent.
Meaning, they knew the information was a lie when they hit the retweet button.
And the sources show the prosecution failed on both fronts.
Completely failed.
They didn't produce the actual verified pension slip of the minister to prove the retweeted one was a forgery?
No, they didn't.
Dr. Chen even noted in his defense that these specific posts were never officially debunked by state media, and many of them remain freely accessible online today.
That fact highlights a glaring contradiction in the state's logic.
I'm listening.
If this information was so dangerously false that merely sharing it to 100 followers caused a serious confusion of public order, why didn't the state authorities utilize their vast administrative resources to delete the original posts or issue a public clarification?
That is a great point. They just left it up.
By leaving the burden of fact-checking entirely to a rural citizen, the state shifts its own administrative responsibilities onto the individual.
And then punishes them for it.
Exactly. It punishes that individual for failing to perform an investigative job they have no capacity to do.
The absolute wildest part of this entire case, the detail in these sources that truly blew my mind, is how the court attempted to prove that second element, subjective intent.
Oh, this part is just, it's hard to believe.
Remember, they have to prove Dr. Chen knew he was spreading lies. They couldn't find any texts or emails of him saying, I know this pension slip is fake, but I'm sharing it anyway.
No paper trail of malicious intent.
None. So to prove his malicious intent, the court used his PhD against him.
The logic they used is staggering. This raises an important question about how the law views intelligence.
The court officially argued that because Dr. Chen has a high education level and holds a doctorate, he, quote, should have been able to distinguish right from wrong, end quote.
Let that sink in.
The legal argument was literally because he is highly intelligent, he must have automatically known the pension slip was a forgery when he saw it.
In legal theory, this concept is known as objective imputation.
Objective imputation.
It occurs when a court assumes your guilt or intent based entirely on your status, your identity, or your demographic, rather than relying on concrete evidence of your actual thoughts or actions.
It's the ultimate PhD trap.
It really is.
They weaponized his own intellect to secure a conviction. They essentially said, "You are too smart to be considered an innocent victim of misinformation, therefore you must be a guilty perpetrator."
It creates a terrifying legal paradox where education becomes a liability.
Seriously.
It implies that the more educated a citizen is, the less presumption of innocence they are afforded under the law.
Because they should have known better.
Exactly. If a person with a high school education retweets a questionable image, the court might consider them duped. But if a scholar retweets that exact same image, they are legally classified as a malicious actor.
Wow.
It replaces the rigorous, difficult work of finding actual evidence with lazy, status-based assumptions.
So what does this all mean? We started this deep dive talking about a scholar in a rural village hitting retweet on his phone. But this isn't just a story about one man's 20-month prison sentence.
No, it's so much bigger than that.
It is a masterclass in epistemology and the architecture of truth. It shows us exactly what happens when a legal system takes the vast spectrum of human experience, art, subjective emotion, academic theory, and objective fact, and forcibly collapses all of those distinct categories into a single weaponized criminal charge of rumor.
Building on that, we have to consider the implications of this logic for the future.
How so?
Well, we live in a world increasingly dominated by digital spaces, right? Where reality is constantly filtered and moderated.
Right, algorithms everywhere.
If a human judge, equipped with a PhD and years of legal training, fundamentally fails to differentiate between a sarcastic political opinion and a deliberate falsehood committing a massive category mistake, what happens next year when we hand that exact same job over to an automated AI moderation algorithm?
That is a terrifying thought.
If the highest levels of human law cannot handle the nuance of art, emotion, and opinion without criminalizing them, how can we expect a line of code to protect our collective memory? In an era of algorithmic truth, we might all be just one retweet away from a category mistake.